Okay, so this is definitely one of the biggest news for the National Democratic Congress right now, because all of us were wondering, say, after the recollation, about 7 out of those 9 contested seats, it could be NPP Fuafano. What was the game for the National Democratic Congress? Remember, say, some youth in the party, they were so much angrier. Some of them even wanted to storm the recollation exercise, but other, if he John Dramani Mahama, say, no one should storm there, and people did not storm there. So afterwards, we were wondering, so what is really next? You see, in Ketia Kacha is a more master plan, and clearly from the announcement and the news about to just see, it is hinting or telling us this particular master plan has already started. I didn't make us the same way. Currently, we know say breaking news this particular recollation the EC did out of the 9 contested seats so far, very controversial. Emu 7 equal NPP 4. Currently, as I'm speaking with you, the Supreme Court in Simbia Babe Tuja. Now, this is coming from Daily Graphic, obviously, as you can see on the screen. It says, recollation saga, Supreme Court to hear NDC's application December 27, which means Yamebua Echna, which happens to be more like a Friday. And the Supreme Court, but normal NDC for application for the Supreme Court. Now, the reason why this is so much a good news for the National Democratic Congress is that EC, I don't even know how to put it. Let me break it down. In 2020, EC the new rule be by your friend is CI and a new law or more amended or more a constitution or the new law be by a friend new law CI 127. Now CI 127 in the EC's rules and in the EC law EC air patches say recollation yenti mean recollation after say yabobo results, which means that we can only do recollation before we announce the results. This was amended in the 2020 EC Constitution. I find it CI 127. So if we are going by the Constitution and the playbook of a Electoral Commission or more amended laws now, which means this particular recollation or either say court ebe bogu and now court ebe say we should go and have a new elections. Secondly, I'll be breaking this down for you to understand where this one is also heading. Secondly, EC argument or the to social media and no reply NDC for John Dramani Mahama a saying Ketia and Sami Jemfi and allegations said by EC now they are working for the New Patriotic Party. EC argument on the by almost citing records of a year Farijan and a year other past members like Charlotte Osea. Basically recollation of course during their tenure, but those cases were 2004, 2008, and before a friend is in the tenure of Jen Mensah. Now Jen Mensah 2020, she amended the laws and on the CI 127 so everything that happened before CI 127 ain't me for because a past sentence. The new law are into effect. It stated just one thing. No recollation after the results have been made. A chair said recollation can only be done before the results. And I said before both parties ABR or more agree. So recollation, you announce the results anywhere. There's no recollation. According to the Electoral Commission one brand after the announcement of the results, no recollation, and any party be out say law and as elections we need to go to court. So ideally the parties which was supposed to be the EC and the New Patriotic Party, they were supposed to go to court to halt the process and as a demand for another re-election and as a recollation and as a by-election. Now we check the body of this because there is a twist to this. I'll say the Supreme Court will on Friday, the 27th of 2024, sit to hear the National Democratic Congress application challenging the High Court's decision to ordered the Electoral Commission to collate and recollate the parliamentary results in 6 constituencies. Now, basically, in this, just telling us the Supreme Court sits on this particular case. Again, an Accra High Court on December 20th ordered the Electoral Commission to bring finality to the election in 6 constituencies by collating the results and declaring the winners the winners in tandem with the electoral laws of the country. Again, the 6 constituencies were Tema Central, Nsawama Dwedri, Ablukuma North, Ahafuano North, and Techiman South, and Okwaike Central. Apart from the order to collate the results and declare the winners, the court presided over by Justice Reverend Joseph Edu Owusu Ajiman further ordered the Inspector General of Police to provide EC with adequate security and recollection at the recollection centers to enable the commission to discharge its duty. So basically, this was a year High Court ruling some time ago. But then CCR, even though a year NDC for the application a common High Court sanka halting recollection, the court subsequently ruled against them, telling them that the EC should go ahead and recollect. Yati and say, but HNEC followed the court's orders to recollect, and no NDC for Asandiako Supreme Court said, based on the law, a year CI 127. EC does not have the necessary permission to do another recollection because the law nature said you can't do recollection after the results have been made public. And any other grievances beyond after the results have been made public, it should go to court. So this is the master argument, the National Democratic Congress going further, going further into a Echinichi Friday. Courts, Supreme Court, this is the argument of making. And one person currently also didn't know about to same air something lawyer, sounds so TV host our Joy News. Or Pacha say the High Court ruling, a year or more allow for the recollection after this particular recollection, all the results, for some reason, weird reason, it is going in favor of the New Patriotic Party. How? Ama a move 7 out of 9 echo. Akwama the New Patriotic Party ebra 2 akano and no the pink sheet crying in the officers said they will not mention it. Isn't that concerning? So based on this, something you need a party say people have gone to school or minimum law. Yet the Supreme Court judges almost law, so that is why they're on the bench. But that ruling which came from the Accra High Court allowing the EC to do recollection, it is void. It is void. That is what something in some of the Ababe to journal. Now, you could see what he said in his entirety. The
law says also that once the gazetting has been done, within 21 days from the date of the gazette, anyone who has any complaints about the process must approach the High Court. I repeat, High Court, not the Electoral Commission. CI 127, on the basis of which the NDC insists that recollation is unlawful, is spot on. They are absolutely right to say for all constituencies where collation has already taken place, there cannot be recollation. Now check CI 127. You will find that there is no mandate after the returning officer or an officer so appointed who has made the collation and the declaration. There is no room for recollation and redeclaration where the collation has been done and the declaration has been done. Now, Raymond, check the Act 284. At 284, let's look at specifically Section 20. Section 20 concerns grounds for cancelling election results. This ground must be canvassed in a court, not before the Electoral Commission headquarters.
The video of them.
So it says these are the grounds: general bribery, general treating, general intimidation, or other misconduct or circumstances, whether similar to those specified in this act or not, have so extensively prevailed that they may be reasonably supposed to have affected the result of the election. That there has been non-compliance, Raymond Magda,
Okay,
The
non-compliance.
Talking about what? Non-compliance.
Non-compliance,
right?
anyway, yeah.
That there has been non-compliance with a provision of this act, or, mark that again, or of the regulation, and that it appears that the election was not conducted in accordance with the principles laid down by law, and that non-compliance affected the result of the election. Or C, that a corrupt or illegal practice was committed in connection with the election by the candidate, or with the knowledge or consent of the candidate, or by an agent of the candidate, or that the candidate was at the time of the election a person not qualified or a person disqualified for election. So once a collation has happened and a declaration has occurred, my respectful view of the law, which appears to be the plain reading of the law, not that I am seeking to interpret it, is that there cannot be a recollation. If the collation, whether it was marred by whatever conduct, as the law says, whether it was marred by intimidation, it was the result of a duress, whether or not the person who did the declaration is not qualified, and whatever the reason may be, the forum where a recollation may happen, the forum where recounting may happen, the forum where a new declaration may be occasioned is not any place other than the High Court.